At 2:17 p.m. Eastern Time, inside a House Judiciary Committee hearing room, a procedural sequence began that could not be reversed. The clock did not stop. No objections were raised. A member was recognized. Documents were entered into the record. From that moment forward, the issue was no longer whether the Epstein matter would resurface, but how far the institutional consequences would travel. The hearing itself was not convened for spectacle. It was an oversight session, scheduled weeks in advance, governed by fixed rules. Witnesses were sworn, time limits were enforced, transcripts were recorded. Nothing about the setting suggested disruption. That is precisely why the disruption mattered. When procedure is followed exactly, outcomes carry more weight. The member recognized at that moment was Representative Thomas Massie. He did not announce an accusation. He did not offer commentary. He identified documents, cited prior testimony, and asked a sequence of questions that were already constrained by the rules of the room. This was not an ambush. It was a deployment. The mechanism at work was simple. Under House rules, any document introduced without objection becomes part of the permanent congressional record. Once entered, it can be cited, referenced, and used as predicate material for future subpoenas. It does not require consensus. It does not require a vote. It requires only that the witness and the committee be present. Massie introduced 4 such documents. Each had already been published. Each had already circulated. None were classified. Their significance was not their novelty, but their aggregation. When placed together, they described a pattern of investigative restraint surrounding Jeffrey Epstein that spanned years, agencies, and administrations. This is where the situation changed. Oversight hearings typically function as controlled exchanges. Witnesses rely on prepared language. Members ask predictable questions. Time expires. Nothing advances. What occurred instead was a narrowing. Massie's questions reduced the available answers to binary choices: yes or no, possession or absence, review or neglect. The legal mechanism being applied was oversight leverage. Congress does not prosecute, it does not indict. It compels disclosure and establishes records. Those records, once established, are not subject to revision by the witness. They can only be supplemented or contradicted later, under oath. Massie focused on FD 302 forms. These are FBI interview summaries. They are not rumors. They are not press accounts. They are internal records documenting statements made by witnesses to federal agents. Their existence is not disputed. Their content is controlled. Their relevance lies in what they contain and who has reviewed them. According to prior investigations, these FD 302s include victim statements alleging that Epstein trafficked individuals to other men. The identities of those men were not named publicly during the hearing. They did not need to be. The only fact that mattered was whether the Bureau possessed such documents and whether its leadership had reviewed them. The answer was incomplete. This is where financial pressure begins to surface, even if no dollar figure was mentioned aloud. Epstein's network involved assets, institutions, and settlements measured in hundreds of millions. Non-prosecution agreements have quantifiable downstream effects. Civil liability, deferred prosecution, and sealed records all translate into financial insulation. Those protections compound over time. Every year without action increases exposure for future administrations. Every sealed record increases the cost of eventual disclosure. This is not abstract. It is actuarial. Massie then addressed jurisdictional constraints. Prior justifications for limited action often cite the 2006-2007 non-prosecution agreement in Florida. That agreement, however, does not bind later investigations in New York. The Southern District of New York pursued Epstein in 2019. That case generated extensive material, different warrants, different scope. This distinction matters because it collapses a common escape route. If constraints no longer apply, inaction requires a different explanation. We will return to this. The witness attempted to rely on institutional process. He referenced prior reviews by U.S. attorneys' offices. He cited interagency cooperation. These are standard defenses. They diffuse responsibility. They imply completeness without specificity. Massie's response was procedural. He did not challenge motives. He asked whether the documents existed and whether they had been personally reviewed. The gap between institutional assurance and individual knowledge widened. That gap is now documented. Another escape route was attempted. The witness emphasized victim protection and credibility assessments. Again, standard. Again, insufficient. Oversight does not require public disclosure of names. It requires acknowledgement of records and actions taken in response. At this point, the hearing moved from paper to posture. Silence followed a direct question. In legal settings, silence is not neutral. It occupies time. It signals constraint. It becomes part of the transcript. The transition from paper judgments to physical enforcement does not happen immediately. It happens through triggers. One such trigger is the creation of a record that justifies compulsory process. Subpoenas require justification. Justification requires documented uncertainty or contradiction. That justification now exists. Asset-by-asset exposure was not enumerated in the room, but it is implicit. Financial institutions referenced in related materials operate under regulatory regimes. Political figures referenced are subject to disclosure laws. Private individuals referenced face civil exposure. Each category carries different vulnerabilities. Consider reputational risk. Consider compliance obligations. Consider discovery. None of these require criminal charges to activate. Systemic implications follow naturally. Oversight hearings are visible. They are indexed. They are searchable. Future committees inherit their records. Future members can cite them without reopening debate. This is how precedent forms quietly. There is also the matter of interagency boundaries. Questions were raised about intelligence community files. The response was conditional. Conditional language in sworn testimony signals either lack of access or unwillingness to confirm access. Both invite follow-up. Deadlines now exist, even if they were not announced. Requests for supplemental answers, demands for document production, scheduling of additional hearings. Each step has a calendar. This is where inevitability replaces outrage. Nothing in the exchange alleged guilt. Nothing assigned motive. The pressure comes from sequence. If documents exist, they must be reviewed. If reviewed, actions must follow. If actions do not follow, explanations must be provided. Each explanation narrows options further. We return now to the jurisdictional point. The Southern District of New York's involvement removes the Florida Agreement as a shield. That means future inquiries cannot rely on expired constraints. They must address current authority. This is also where financial exposure resurfaces. Civil litigants monitor congressional records. Regulatory agencies do the same. Acknowledgement of unreviewed material creates opportunity. Opportunity invites action. The conclusion of the hearing did not resolve anything. It did not need to. Resolution is not the function of oversight. Activation is. What happens next is procedural. Written questions for the record will be submitted. Responses will be due by a fixed date. Failure to answer fully can trigger further action. Parallel inquiries may reference the transcript. 3 developments now matter. First, whether supplemental answers confirm personal review of the relevant documents. Second, whether additional witnesses are scheduled to address interagency file sharing. Third, whether document requests expand beyond prior scopes. None of these require speculation. They follow from the record already created. The system does not move quickly, but it moves predictably. When a mechanism is engaged properly, it advances on its own timetable. The hearing ended, the clock continued, the record remains.